Hi everyone. So today's session is Introduction to Law and Practice. My name is Shazia Khan, and the learning outcome we'll be doing today is learning outcome 2, which is to understand how Parliament passes an act of Parliament. But before we go into learning outcome 2, I just want to give you an overview of what we did in the last session, which was learning outcome 1. So in the last session, we looked at understanding the structure of the English legal system and how it works in line with different elements such as common law, equity, things like that. So we looked at the introduction to the historical general development, understanding how law has developed. We looked at equity and how it works in the legal system. We looked at the concept of criminal law, civil law, the burden of proof, balance of probabilities, and we looked at remedies as well. We also looked at the structure of the English legal system and key features of that. We looked at the sources of law, such as legislation, common law, European Convention on Human Rights, and customary law. We went on to look at the hierarchy of the courts, and how it's structured. So criminal courts, we looked at magistrates' court, Crown Court, Court of Appeal, Criminal Division, and Supreme Court. In civil courts, we looked at the county courts, High Court, Queen's Bench Division, Chancery Division, Family Division, Court of Appeal, Supreme Court, and specialised courts. We then went on to look at the roles of the legal personnel, and we looked at what alternative dispute resolution was. We then went on to look at 1.1, which is differences between civil and criminal law. We looked at the purpose, the parties involved, the standard of proof, outcome examples, the court that it's dealt with, legal representation, both in civil and criminal courts. We went on to then look at 1.2, which was the organs of the government, the European Union. So we looked at the legislature, executive, and judiciary. We then went on to look at their functions. We looked at the European Union and the purpose of the European Union in regards to Brexit as well, and what impact it had on the economy. We looked at the concept of criminal law and the purpose of that, and we looked at the concept of criminal law. We looked at operation and burden of proof. We looked at the element of 1.4, which is what is law and its impact on society. We looked at the UK Constitution and its structure. We looked at the executive, judiciary, and how the organs fit together and how they work together. We looked at the impact of law on society as well. We looked at 1.5 differences between common law and statutory law, and we looked at the element of the impact of law on society and how it impacts on, the day-to-day society and criminal law, and how it impacts on, the public, how it impacts on things like equality, the economic growth, accountability, how law impacts on society as a whole. So that was learning outcome 1. Now we're going to go on to learning outcome 2, which is to look at understanding how Parliament passes a law. So we look at the element of how laws are passed in regards to, the element of legislation and how a law is passed through elements of, the difference, the process that it goes through, because it's quite a lengthy process that it goes through. So the indicative content for learning outcome 2 is to look at the green paper and white papers formal consultation, the process papers go through, the law, the role of the commission and how it operates, public bills, the different types of bills we looked at, private bills, hybrid bills. Then we looked at the process that it goes through: first reading, second reading, committee stage, report stage, third reading, and roll assent, and the role of the purpose of delegated legislation. So the key terminology, so the legislative process is a bill is proposed through Parliament, then it's gone through a process, and then it's gone through the element of the different stages, and then it's gone through delegated legislation and passed through Parliament. So what types of legislation does UK have? So they have primary and secondary legislation, which we'll look a little bit at later on. Here is a video, and this video outlines the parliamentary legislative process within the UK and how the process is how an act is passed through Parliament, and what the process is, and why there's a need to have that process, and why there's so much scrutiny when it comes to it. So the process by which Parliament is structured and formal process, it ensures that new laws are debated, scrutinised, and this is really important, to identify that laws are passed properly. So a bill is proposed, like we said, through Parliament, debated by both houses, so House of Parliament and House of Commons, and then it receives royal assent by the King, and then once it's received royal assent, it then becomes a bill, then becomes an Act of Parliament, and it's one that everyone has to follow, and there is a procedure that it needs to go through, and it's something that goes back and forth until it's right. So they don't just pass something just to say that it's, going to be the law. They have to go through a procedure. So the key institutions involved in it are the House of Commons, and they are elected members of Parliament, and they're responsible for debating in the element of passing the law. Then you have the House of Lords, and the monarch who signs it at the end of it. And unless it receives royal assent, it won't be passed. So it needs to receive royal assent before it could get passed as an Act of Parliament. So now we're going to go through the stages in passing of the law. So there's the legislative process. So they have the Green Paper. This is a consultation document proposing any sort of laws, and then they have the White Paper, which is a refined document of the final proposals, and we'll go through that later on a little bit. So you've got the legislative process here. And the legislative process, they have a first reading, which is so through it they have to go, and this is the first official stage of a bill. So here the short title of the bill is read out, and then an order for the bill to be published is made. This is when the full text of the bill is made public, usually accompanied by some explanatory notes, and it's purely procedural event, so there's no vote, and the bill cannot be discussed or amended in any way. So it's an introduction stage, sorry. Then the second reading, this is when a bill is first debated. For a government bill, a minister opens the debate, and then shadow ministers and backbench MPs have the opportunity to make their points about the proposed legislation, and the details of the bill cannot be changed at this stage. But an MP can table a reasoned amendment opposing the bill. So if the Speaker selects the reasoned amendment for a decision, it will be voted on before the vote on second reading. If the bill is defeated at second reading, it cannot be reintroduced during the same parliamentary session. A defeat at second reading is a rare occurrence for government bills, with the last one happening in 1986. And after the vote on a second reading, the House approves a programme motion setting out the timetable for the remaining stages. Then you have the committee stage. Here, this is generally the longest stage of the bill's passage and where the most thorough scrutiny takes place. So here where everyone looks at and scrutinises it. Most bills are referred to a public bill committee, and the membership reflects the party composition of the House, and the majority government therefore rarely loses a vote in committee. Constitutional bills, bills of major importance, and highly controversial bills are taken in a committee of the whole House, meaning all MPs can contribute here. MPs conduct clause-by-clause scrutiny, and public bill committees can also take oral evidence from key stakeholders. Each clause must be agreed 2 amended or removed, and the new clause may be proposed and agreed to. The government tables almost all of the amendments made. If it agrees with the idea behind an opposition or backbench amendment, it will normally try to introduce an amendment on the subject at report stage. The next stage is, after the committee stage, is the report stage, which is the consideration stage. This stage usually takes place 2 weeks after the committee stage, and if the committee stage was taken in the whole House, then this stage is skipped unless the bill has amended there. The debate can take place over more than a day, but normally lasts between 3 and 5 hours. All MPs can propose amendments or new clauses to the bill, and the Speaker decides which ones are discussed and voted on. This stage generally leads to fewer amendments being debated than at the committee stage, but more amendments are made overall here. And then you've got the third reading. This is the final opportunity to debate a bill, usually immediately after the report stage ends, often on the same day, and usually lasting up to an hour. The debate often involves MPs and ministers making speeches congratulating those who have worked to get the bill to the stage. And here the MPs then vote on whether to approve the third reading of the bill. And the last defeat of government bill at this stage was in 1977. House of Lords, so if the bill started in the Commons. So the House of Lords follows the same bill stages as in the Commons, with a few differences. The Lords is self-regulating, so there's no limit on time spent. During the committee stage, rather than being sent to a bill committee, the bill is usually debated on the floor of the House, or in the case of a minor bill, in Grand Committee. All members can take part while amendments are tabled, and it is rare for them to be voted on at this stage. This usually takes place at the reporting stage. At the third reading, a bill can be amended if the amendments focus on something that has not been voted on previous stage. Usually this stage is usually for tidying up the bill rather than making any sort of major changes. The Lord Speaker does not select amendments, so every amendment can be debated. Members tend to only press amendments to a vote if they are concerned about the issue and they want the government to think again. If a Commons bill is defeated in the Lords, then it fails. But since Parliament Act 1911, if the Commons pass an identical bill again in the next parliamentary session, it can receive royal assent without going to the Lords. Under the same Act, the Speaker can designate financial bills as money bills if they delay solely with taxation, loans, or public money. A money bill can be presented for royal assent even if the Lords do not agree to it. Under the Salisbury Convention, the Lords will not block bills at second stage. They are part of government's manifesto commitments. And then we've got the consideration of amendments, which is after the Lords have considered a bill, it will be sent back to the Commons or vice versa. If the second House does not amend the bill, then it goes for royal assent. If it has been amended, then the amendments return to the first House, which can reject the amendments, agree to them, or propose new ones. The bill then returns to the second House for it to consider any changes, and the first House has made. This process is known as ping pong, continuing until the Houses are in agreement. If there's a deadlock is reached, then the bill fails. And the final thing is the royal assent. This is the final stage of a bill. Once both houses agree on it, or just the Commons if the Parliament Act has been used. If then it goes to Monarch, who will then officially agree to make the bill an act of Parliament. So that is the final attempt. So we've got different types of bills here as well. So you've got government bills that are proposed by government based on manifesto. You've got private bills who change the law for a limited set of interests, such as a single organisation or an individual. And then you've got the public bills as well, They apply to everyone, and either the government or backbench MPs propose them. Most bills are public. And then you've got the hybrid bills, which combine elements of public and private bills and are used in very specific circumstances when a bill has both a broad public purpose and will affect people at a local level. So the function of passing a bill is to implement a policy, so reflecting on any sort of priorities that the government wants to change, maybe in areas of education or health, creating a legal framework for society and to protect rights of individuals, adaptation to change, addressing any sort of any climate issues or any issues relating to technology. An example of a change made by the Act of Parliament is the Equality Act, which introduced the measures of equality. So in conclusion, the process of passing a bill is quite a long process, but it needs to be considered and there needs to be scrutiny in both passing of the bill and then receiving royal assent. So as the process goes, the first reading, the second reading, third reading goes through on the committee stage. The whole purpose of that is to prevent any sort of elements that the bill goes through as an act of parliament, and there's scrutiny by both houses, House of Commons and House of Lords. So 2.1 is to outline the role of the Royal Commission. So the Royal Commission is so the Law Commission is a statutory independent body, and it is created by the Law Commissions Act 1965 to keep the law of England and Wales under review and recommend reform where is needed. And the aim of the Act is to ensure that the law is fair, modern, and simple for individuals to understand that. And it's really important that it is an independent body that is there to make the law fair, cost effective, but modern, and to make sure that it's understood. The Commission considers reviewing an area of law reform against certain criteria. So if it's important, the extent to which the law is unsatisfactory and the potential benefits from refrain. So it looks at elements of that. Before deciding which projects to take forward, the Law Commission takes view from judges, lawyers, government departments, and the voluntary and business sectors and the general public to see what they think. How the Law Commission operates. So, it's a criteria used to select new project, and it looks at things like importance of the law, suitability, and the resources available, and the stages that it goes through in regards to that. It selects initiation stage, pre-consultation stage, consultation stage, policy development, and all stages of the work from the selection through to making recommendations will impact on reform, making sure that, there is areas that need to be reformed within the Law Commission. What the Law Commission produces. So the Law Commission produces recommendations, initial consultation papers, and final reports. So to identify any changes. They also produce statutory law reports and codification projects as well. And examples of Law Commission reports: domestic abuse 2018, which was obviously strengthened legal protection for victims of domestic abuse, automated vehicles 2022, and leasehold enfranchisement in 2020. The importance of the Law Commission is it's an independent body, and they are there to ensure that the law is fair. And, they are there to ensure that the legal system keeps pace with the societal system as well and reduces any complexity, promotes fairness and helps reduce any sort of costing for individuals, and it's independent, so it's there to provide a fair decision at the end of it. So the Law Commission plays a vital role in the legal system. By conducting research and getting consultation papers together, it makes recommendations to improve the law for individuals, society as a whole. And, there was examples of the homicide laws and the regulations, and the domestic violence one that we mentioned earlier. 2.2, description of delegated legislation. So what is meant by delegated legislation? What is delegated legislation? Delegated legislation is law made by ministers under powers deriving from acts of parliament. Thousands of pieces of delegated legislation, commonly known as statutory instruments, are passed by parliament each year. So there's different types of elements of delegated legislation. So role and purpose of delegated legislation. So modern governance requires a large amount of legislation, which may often be technical and need speedy amendment or regular updating. Parliament does not have the time or capacity to legislate at scale, pace, or level of technical detail needed. Putting the required level of technical detail into Acts of Parliament would in any case make these longer and harder to understand. Parliament therefore often establishes the framework of policy acts and delegates the power to make detailed legislation within the framework. So delegated legislation is very common and necessary for the modern governance. It becomes a problem only when it's used inappropriately. So, it's can be used in accordance with powers that act by the Act of Parliament. And, it needs to be taken into account when it's used as well, and make sure that it's used properly. So, they can't always pass. It's make sure, it's efficient, flexible, and specialization and local governance. Who delegated legislation can be delegated to? Government ministers, often the power to create statutory instruments. Example, the minister making regulations, local authorities to make the laws applicable to jurisdiction, public bodies, corporations. And how delegated legislation works, it specifies what can be done. Example, the Road Traffic Act 1988, it provides a framework and it includes oversight mechanism. Types of delegated legislation. So first one is statutory instruments, and statutory instruments refers to the rules and regulations made by government ministers. They are given authority to make regulations for areas under their particular responsibility. A good example of statutory instrument is what this means is that the Lord Chancellor has the power regarding the legal aid schemes, while the Minister for Transport is able to deal with the necessary road traffic regulations. The use of statutory instruments is a major method of lawmaking, as there are about 3,000 plus statutory instruments brought into force each year. There are many acts which give Minister of State power to make delegated legislation. Some examples which are the Constitutional Act 2005. And then we've got bylaws. And bylaws can be made by the local authorities to cover matters within their own area. For example, West Yorkshire County Council can pass laws affecting the whole county, but a district or town council can only make bylaws for its district or town. Local bylaws can involve traffic control, such as parking restriction. Bylaws can also be made by public corporations and certain companies for matters within their jurisdiction when involve the public. This means that bodies such as the British Airports Authority and the Railways can enforce rules about public behaviour in their premises. An example of this can be smoking ban on the London Underground. And then you've got the final ones, orders in council. And the Queen and the Privy Council have the authority to make orders in council. The Privy Council is made up of the Prime Minister and other leading members of the government. This type of delegated legislation effectively allows the government to make legislation without going through Parliament. So its main use there is to give legal effect to European directives. However, the Privy Council has the power to make law in emergency situations under the Emergency Powers Act 1920 and the Civil Contingency Act 2004. Orders in council will be used to make other types of law. A good example is in 2004, the order in council was used to change the Misuse of Drugs Act 1971 to make it cannabis a Class B drug. So these are the different types of delegated legislation. So the limitations are delegated legislation is not without constraints and challenges. So there are many problems. There are many problems with both delegation of powers to make delegated legislation and scrutiny of statutory instruments that arise these powers. A number of there are different elements that work with it. So parliamentary oversight, delegated powers are subject to scrutiny through affirmative or negative resolution process. Judicial review, so courts can review delegated legislation to ensure it does not exceed the power authority granted by the Parent Act. Or democratic deficit, overuse and complexity, and the sub-delegation as well. So these are limitations of delegated legislation. So it's not just something that goes through quite easily. There can be challenges and constraints for that. But delegated legislation plays a crucial part in the legal framework, enabling efficient governance by allowing specialized, detailed, and adaptable rules to be created. So while it provides flexibility, it's bounded by Parliament, and there are some constraints to the misuse of it as well. Next one is 2.3. Explain the formal consultation process. So the formal consultation process is a critical stage in the development of new laws or significant policy changes. The process begins with the green paper and progresses onto the white paper. So the green paper and the white paper. So the green papers are consultation documents produced by government, and the aim of the document is to allow both inside and outside Parliament to give the department feedbacks on its policy and or its legislative process. Green papers are aimed to use to debate on a certain subject. The purpose is to facilitate public discussion, explore a range of options, and encourage dialogue. And the example is the 2020 Green Paper on transforming public procurement, invited feedback on improving procurement practices post Brexit. And then we have the white paper, and this is a research-based report which offers a focused description of complex topics and presents the point of view of author or body represented by the author, is to give readers an issue which in turn helps solve a problem or makes a decision. So this is an approach to a policy of legislation, and it provides a framework of drafting the bill. And the main goal of a white paper is to highlight features of solution and any sort of amendments that need to be made. And that was the 2021 white paper on health and social care reforms, which outlined plans for integrating NHS and local authority. So the formal consultation process involves the following stages. So drafting the green paper, which is identifying any sort of issues and coming up with solutions. And then secondly, the public consultation, gathering input from a wide range of sources, members of the public, it could be legal academics, and then methods of consultation. It uses online surveys, submission of written reports, public forums to get them involved and see what they decide on it. And then we have the analysis of feedback. So it's really important that they get feedback on it and refine any sort of proposals. and directing the white paper, so making sure that the government final proposals shaped by consultation feedback, if any changes need making, and further consultation, and then preparation of a draft bill. Benefits of the consultation process. So the whole point of it is to increase public trust in the element of transparency, make sure that they've got informed decision making and inclusivity, make sure that they're able to plan the policy and decision making, make sure that things are in place, provide a platform for diverse voices as well, reducing any sort of resistance within the legislative process. So example in the diagram of green paper, white paper. So the green paper was the Future of Transport 2020, and the purpose was to sort views on creating greener and more sustainable transport systems. And then the white paper was the Education Reform 2022, which was there to propose reforms to improve teacher training and school funding. So these are some examples, and they're really important when it comes to conclusion in regards to the process. Green paper and white paper is essential to make it fair and practical, and allowing input from stakeholders and public so that it's supported and becomes a law. So it's really, really important in regards to that. The next one is 2.4, analysis of the stages involved in the creating a process. So each year Parliament so it opens a new session, and there's no fixed length for parliamentary session. They usually spring to spring with a number of breaks. And on the day of the session, the reigning of the monarch will read out the speech written by the government that sets out policies and then sort of propose parliamentary session, and this is known as the King's Speech. And this goes through that ensures that the scrutiny is gone through and the bill has been passed properly. So the first reading, as we said earlier, the introduction to the bill, and this is where the element is, where the bill is introduced and published. And then the whole point of the first bill is the element of introducing the first bill and making sure that it's introduced and published. Then the outcome of that is the bill is formally introduced. The second reading is the bill is debated and voted on, and this looks at the merits and if there's a need to go to the next stage as well. And then you've got the element of the committee stage, which is line by line examination of the bill. So this is where the scrutiny starts coming in place of the bills, whether it should go through, if there's any sort of amendments that need to be made. They would here submit evidence to the committee to show our current Human Rights Act matters, whether there's a change that needs to be made. And here the example was during the committee stage of the Health and Social Care Bill 22 specific clauses on workforce planning were added. And then the report stage, so any changes can be suggested and debated here, and the MPs focuses on points during the committee stage and ensures the bill is comprehensive and accurate for the final reading. So this needs to be going through. The example is amendments to environmental concerns were introduced at the report stage of the Environmental Bill 2021. The third stage is the final debate and vote on whether the bill should continue. And then the bill here will move on to the House of Lords. So, this moves on to the House of Lords stage where they actually go through all the stages as well. So in the House of Lords, which moves on to the House of Lords stage, they will go through the same stages as it does in the House of Commons. And the Lords have various opportunities to debate the bill here, add any sort of changes or amendments, and vote on whether the bill should continue. The third reading in the House of Lords provides the opportunity for the Lords to tidy up the bill making sure that the eventual law is effective and workable without any sort of loopholes. Unlike the House of Commons, changes can be made at the third reading in the House of Lords, but only if the issue has not fully been considered or voted on previously. Usually, these changes are usually to clarify any sort of specific parts of the, any sort of issues around it. And then the House of Lords can have a powerful impact on bills from the House of Commons. In the last year in Parliament, they voted against the government 129 times. Interventions from the House of Lords in recent weeks have led to important changes as well. So then they have the consideration of amendments. And here, this is resolve any sort of disagreements between both houses. And if there's, this is the process until both houses agree to the final text. And it ensures consensus between the Commons and the Lords. And then the final stage is after the bill has been approved by the House of Commons and House of Lords, it returns back to the Houses, and the two houses deal with it. And then it is after that royal assent is given, implementing the law becomes the responsibility of the government, and here the law may immediately or after a certain date take act, and it becomes from a bill, it becomes an act of Parliament, and the bill becomes an act and part of the law. So the example is the Animal Welfare Act 2022 received royal assent and became a law. In this diagram, it shows the key features of the process. So first reading, second reading, committee stage, report stage, third reading, and royal assent. And it gives the importance of the purpose of that, each reading, and the outcome of it as well, whether it becomes a law or whether what stages it comes and where it processes and how it passes through. So it's really important. The legislative process is really important within to scrutinise any sort of laws or anything, to make sure that the readings are being passed, and make sure that the law has to follow this procedure to go through, because, it involves both houses, and it makes sure that there's scrutiny in the process, and make sure that the final thing is the final thing to be agreed by both houses, and then signed by the monarch to become an act of Parliament. So the UK, there are different types of bills. Bills are categorised as public bills, private bills, hybrid bills, and we'll go through each one. So the public bill is a government bill, and it's laws that apply to the entire population, and the specific groups within society. So the purpose of the bill is to introduce the amend or repeal any sort of laws affecting any sort of elements of public policy, or any sort of elements of the different, the societal needs. So they're introduced by government ministers, and they are sometimes by individual MPs. And an example is the Equality Act 2010 and the Education Act 1996, sorry. And the different types of bills, we've got the next one is the private bills. And these are bills suggested by a person, a group, or a company, individuals, organisations, and they're usually for a particular, they normally affect the general public, and the purpose is to grant special legal powers to exemptions and introduced by organisations such as local authority. An example was the University College London Act 1996 to reorganise the governance structure, and the Canterbury City Council Bill. Procedures notices are issued to those affected and evidence is presented in a committee, and then affected parties can object here. Then you have the hybrid bills, which are government bills that affect interests in a certain way. And as well as impact on the general law, they also impact on organisations and groups. And they are used to often used for large infrastructure projects, are usually by the government, as I mentioned, and the examples of High-Speed Rail Act 2017 and the Channel Tunnel Act 1987. Procedure follows a mix of public and private procedures and includes opportunities for individuals. So in this diagram, it looked at the elements of the different public bills, private bills, and hybrid bill, and the scope of it, the purpose of it, is introduced by, and the examples of the procedure of it. So how they operate. So a bill is proposed law which is introduced into Parliament. Once the bill has been debated and then approved by each House and received around the Senate, it becomes a law, as we mentioned. So you've got public bills which are widely debated in Parliament. And they focus on elements of widely debated in Parliament, and they are focused on issues like health, education, and social welfare. And then you have the private members bill, which is bills introduced by MPs and peers who are not government ministers. Parliamentary time is controlled by the government and almost their legislation by ministers. Private bills are introduced in the House of Lords and run a ballot, which some private members' bills are drafted by government departments and given backbenchers. These are known as handout bills. And then you have hybrid bills as well, which are significant public scrutiny and parliamentary scrutiny. Hybrid is a government measure which affects particular individuals or organisations, and it's in the interests of the private. So, you know, it's submitted petitions to the people that are affected, and it's subject to petition. Often a hybrid bill often involves detailed committee headings, and some examples is the railway bill promoted and sponsored by government, and the Park Planning Act 2008. So, you know, these elements of these three bills work in different ways. So each bill serves a different purpose, you know, and it works differently. And the public bills and private bills, it affects different people. So, you know, the way they work and the way they implement things is different. So you can't just use one bill for everything, and understanding the distinction between all the three is really important because it looks at the changes in society and why there's a need to have this in place, and why there's a need to have three bills, private, public, and a hybrid bill as the main ones to deal with societal issues and changes in society and who can bring them about. So we finished learning outcome 2 now. I'll just give you a summary of what we've gone through in learning outcome 2. So we've looked at understanding how Parliament passes an act. We looked at the green paper and white paper formal consultation process. We looked at the role of the Commission, how it operates and how it produces examples of some of the reports. We looked at the key institutions involved in the legislative process, such as the House of Commons, the House of Lords and the Monarch. We went to the stages in passing an act, which is a first reading, second reading, committee stage, report stage, third reading, House of Lords stage, consideration of amendments and royal assent. We looked at the types of bills that went through, so government bills, private members' bill, public bills, and hybrid bills. We also looked at the role of the Law Commission and how they operate. We looked at the description of delegated legislation, the role and purpose of delegated legislation, and we looked at the types of delegated legislation, which are statutory instrument, bylaws, orders in council. We looked at the green paper, white paper, and why they're so important, what the purpose of these are. We've looked at the formal consultation process, benefits of the consultation process, like transparency, informed decision-making, conflict mitigation, inclusivity. We then went on to look at the analysis of stages involved in creating an act. Again, the first reading, second reading, committee stage, report stage, third reading, House of Commons, consideration of amendments and the purpose and processes of each, and the royal assent. We looked at the element of different types of bills. So we looked at the purpose, examples and the procedure for public bills, private bills, and hybrid bills, and the comparison and why they are so important in regards to the UK Constitution. So that was a summary of what we've done in Learning Outcome 2. These are some of the references that we've used for Learning Outcome 2, and you can refer to these if you want any additional reading, as there's links there to each one. Also, I've put a link there for a PDF document that you could refer to if you want to do some extra reading around the legislative process and how it works in the UK. Please refer to any ebooks and journals on Moodle for this unit. If there's anything you need to go on to Moodle, will have your assignment brief on there, any additional reading on there that you can refer to. Have a look at that link there that I've put. It's a PDF document on the legislative process, which would help you better understand how it works. And then if you have any questions or any questions around anything to do with the session, Learning Outcome 1 or Learning Outcome 2, please email learnerwork@ukvarsity.co.uk. Submission of the assignment to be done on learnerwork@ukvarsity.co.uk. Also, if there's any sort of questions around the assignment brief is available on Moodle. Please go on to Moodle for the assignment brief. And if you have any questions, please email learnerwork@ukvarsity.co.uk. The recording for Learning Outcome 1 and 2 are both available on Moodle for you, will be available on Moodle for you. And also the next Learning Outcome is Learning Outcome 3, and then we'll have Learning Outcome 4, the assignment discussion session. Thank you for attending today's session. Thank you. This is the end of the session.